Well, of course, seller. I'm at this point, I think the chief concern or the chief virtue of arbitration does become enforceability. That arbitration awards are enforceable abroad under the New York Convention. And if we're a U.S. party, it's going to be a whole lot easier for us to enforce an arbitration award in any of the 146 New York Convention states, which is pretty much every state where there's likely to be assets that we can levy on. But the concern about, we can enforce an award under the New York Convention quite easily. We can't enforce a judgment of any court, any U.S. court, so that's not going to work. It's fairly difficult to enforce, outside of EU judgments in the EU. So there, I think we've got a fairly intra-EU. It's it's not exactly the easiest thing either. So we've got a real benefit from enforceability, and that's probably the chief among them.
If GE is likely to be a seller in a transaction like that, a provider of a technology, a seller of a good.
Right.
So more often than not, the claims will be against you, except for claims for payment, where you'd be seeking payment. So in those circumstances, you really got to take into account the nature of the system that you're being asked to consider. For example, I live and work in London. I would have no qualms whatsoever about submitting something to the courts of London. The things I know about it, however, is it's going to be very expensive. It could take a while, but I think that they tend to be very, very reliable on technical matters. The French courts, on the other hand, we also know that the courts of first instance in France are routinely knuckleheads. It's common among French lawyers for them to tell you that cases are really decided at the appellate level, and that the quality of judges at the first instance level is extremely variable. They're very good in Paris and some of the other major metropolitan centers, but not necessarily, and certainly not outside that. So as a seller, you may be a little more concerned about you want a tighter control, I think, on the decision process, because what you're trying to do is to usually enforce limitations on damages, contractual restrictions on their ability to proceed claims against you, the choice of law you've negotiated. And in arbitration, in most countries, that's going to be easier, or you're going to have a greater feeling of security that you can do that.
Another thing, and adding on to that, is when you're looking at these different countries, you may want to look at their discovery rules compared to them. If you're a company like GE, do you want to go somewhere where they have broad discovery rules where they can go in and ask for everything under the sun, whereas in arbitration you can really limit discovery?
Which, by the way, is an interesting point. I often am told that you can get discovery in certain arbitration. The truth is, most disputes that we're in, we don't really need discovery because it's both parties are equally disadvantaged by not having access to it. And if it's a technical dispute or a big commercial project, usually the dispute is going to be decided on documents, and should be decided on documents that are in the possession of both parties in any event. If the claimant has a claim, they have to prove the claim based on documents they have, not on documents they expect to be able to get from the other side. And at least being based in a civil law company where that's the practice, I'm pretty comfortable with that. I think to your point, is to go into a jurisdiction where I would be subject to very broad discovery obligations and spend a lot of time doing things that really don't advance my dispute. Maybe I wouldn't want to do that.
That's likely to be one of the main reasons why a foreign counterparty would not want to be in U.S. courts, so as not to be subject to that kind of discovery.
Costs are another issue for you. For someone in GE's position, one of the things you want to discourage is frivolous claims, or let's take a whack at them and see if we can extort a settlement out of them. Arbitration, even in England, where costs tend to follow the event, they don't tend to follow on an indemnity basis. In other words, you don't really get your costs back. You get some percentage, and sometimes it's a high percentage, but usually it's less than 50% of your costs to be returned to you as the prevailing party. One thing you can do in arbitration is make certain that costs have been shifted. You can force the arbitrators to shift the costs to the losing party. That gives you a little more security that someone is not, and the cost of the arbitration itself, by the way. It's not cheap to run arbitrations, we know. Will give you a little security that a lot of these marginal claims that people might take a run on in hopes of getting a settlement out of you, it's going to be harder for them to break.
That's right. In fact, the unfortunate thing that I've seen sometimes in contracts that I wish that we had not done is to include provisions that say that the costs of the arbitration and legal fees shall be borne equally by each side, which I really think is a huge mistake, because the biggest deterrent to frivolous litigation in the international context is being able to penalize a frivolous party with your costs. And arbitrators will do that, where the claims are genuinely frivolous.
We have a case right now going on where we represent somebody in a similar position, and it's the opponent wants to bring this claim. It's an ICC arbitration. The amount is not much. It's about $7 million. But it's an individual, and the cost of bringing that proceeding is pretty high. He'd have to invest a significant amount of his own personal worth to bring the claim. And frankly, I think it's a frivolous claim.
And once he puts up the money, then he's at risk of having to also pay ours because the claim is not well founded.
Well, and the first thing we told him is, we will ask for security for costs because we don't believe you can make good on our costs. So we're going to ask you to put up 100%. It's
interesting. Again, this is because you're all American lawyers here, practicing in the U.S. and outside the U.S., and we would all agree that we should not have clauses like that in our dispute resolution provisions that say each side shall bear their own costs. We should probably just be silent, right? Would you all agree that that's as to costs, and let the arbitrators decide who should
That's
pay?
going to depend in the first instance on what your governing law is. You need to know what that law says about whether the prevailing party recovers its costs or not,
right, and
whether you're comfortable with that.
It's interesting. The U.S. lawyers sometimes talk about this being the English rule. In fact, it really is the American rule that the winning party is not entitled to recover some, or in some cases, all of their costs. I think you're right. But the practice in general would be in international arbitration, at least international arbitration outside the U.S., that there would be some entitlement to a costs award to a prevailing party.
Yeah, and you are going to, that's again, just all down to specificity. If you can specify it in the commercial terms of the contract, right, that, costs will be awarded, to the prevailing, the cost of the arbitration, including attorney's fees, shall be awarded to the, prevailing party. Leave some to the arbitrator's discretion in terms of amount. You'll get a higher amount, I would agree with Jim, than you're probably likely going to get in court litigation, even in fee-shifting jurisdictions.
But you probably don't want to be silent about it, because if you're in New York, you wouldn't get your costs. If you're in Texas, it's a contract claim, or if Texas is a governing law and it's a contract claim, you would be entitled to fees. If you're in England, the law of England governs, you'd be entitled to shift the cost. So if you're silent about it, unless you've looked into what the governing law is and what it provides, and looked at whether it's a question of substantive law or procedural law, so it's determined by the governing law or the law governing in the situs, you don't know what the result is going to be, and then you've increased your uncertainty rather than reducing it.
Great point.
You may also want to check, if time is an issue for you, how long in these different jurisdictions it takes these courts to make a decision, how long the trials last, because you can put in your dispute resolution clause in certain instances that this we must have an award within this amount of time. Decisions must be made within this amount of time. It sort of depends on your situation.
Yes, although as I said, our experience with that is that the time limitations that we put into our arbitration, our dispute resolution clauses, last until the arbitrators decide they actually need more time and they ask us for it, and it becomes difficult. We've insisted at times, but you risk self-penalizing.
But probably better that than being in Italian courts.
Yeah. Well, guys, I would disagree with that. In
really?
fact, the courts of Florence, courts of Milan are among our preferred dispute resolution clauses because things go pretty quickly. It is, we can get in and out of the Florence courts. It depends on it's like arbitration. It depends on the judge you get and how big their dockets, how backlogged they are. But some judges you can get in and out of a first instance or a trial court decision within a year and a half, 2 years. In some courts in Italy. Again, other courts, particularly in the south of Italy, it may take 5, 6, 7, or longer years to get a decision. So I wouldn't.
No, that's interesting because it's good to have a more differentiated view of Italy. Because
Well, but the point is that when you're drafting one of these clauses, you need to know what the option is and how to evaluate that. Right. It makes a difference whether you're in Florence or whether you're in Paris or London or Houston or wherever.
Because we know it. It's something that we know and we can manage it very well.
Well, that points out the importance of enforcement strategy. If you're going to put an arbitration or even a court clause in your contract, you need to be thinking about where you're going to be enforcing if you are the party that's like, now, GE is not likely to be in that position often. But you could be. There'll be situations where you're in bigger projects, where you've got equity stakes, things like this, where it will be an issue for you. And you do have to take into account, we have one arbitration award that we were trying to enforce in 3 jurisdictions.